Yes, sir. Now I request you to go with the case laws and the case
Okay.
studies and best practices, and then we will come back to the questions, sir. Will
Question
it be
answer.
okay?
Okay, sir. Okay.
Yes.
Okay.
Thank. To the participants also, my humble request is to have some patience. We will take up your queries also, uh, because probably some of your queries may be covered in this session of best practices and the case studies. Yes, sir. Now over to Sri Jagannath Pati, sir.
Yeah.
Thank you, sir.
Sure. Sure. Uh, before moving, I think to the case laws and best practices. I think since uh, from yesterday the sessions are going on, I would like to just a summary of the provisions of the JJ Act, Section 56 to 73, particularly Section 56 is very important. I would like to just see that maybe the learned participants just have refresh their memory. Like Section 56(1), adoption to be resorted to as per the provisions of the Act, the rules, and the adoption regulations framed by CARA to ensure right to family of OS children. OS means orphan, abandoned, surrendered children. A non-Hindu living in India can adopt under the JJ Act. Any earlier it was not possible for adoption was not was difficult for Christians and Muslims to but now under JJ Act we see several cases of such community adopting under the JJ Act. Nothing in the JJ Act shall apply to the adoption of children made under the provision of HAMA. See, in HAMA, there are no checks and balances. So HAMA talks of intercountry, sorry, JJ talks of intercountry adoption. JJ talks of agencies and authorities. JJ talks of this regulation and rules. So we are because JJ is a child friendly. JJ is a child friendly legislation, and yes, can you hear me, please?
Sir, there are disturbances. Kindly
Yeah.
ensure that.
From
बंद
your
केलं
side,
सर
no difference.
विद्वान साहेबांकडनं होतं केलं बंद केलं.
Yes, yes, thank you.
Uh, Then nothing in the JJ Act shall apply to the adoption of children made under the provision of HAMA. I think that is clear. All inter-country adoption to be done as per the provisions of the JJ Act, adoption regulations by CARA. Why? Why it is so? Because Government of India have ratified the Hague Convention on Inter-Country Adoption in the year 2003, and there are certain protocols like issuing issue of Article 5, issue of Article 7, compliance like the child study report sending from here, then home study report receiving from receiving countries, then issue of this NOC that comes under Article 17, and then issue of conformity that comes under Article 23. So these all requirements or stipulations have been provisioned under the JJ Act. So anybody who does this mistake, foreigner coming to India and going for Hama adoption, registering with a deed and asking for CARA NOC, it will be really difficult, almost no possibility. And if CARA doesn't issue NOC, then he will be stuck with passport, maybe with then visa, then exit visa everywhere. There will be, without CARA NOC, they will have problem. Okay, so in cases of see the Hague Convention and inter-country adoption, that is there are two issues. One is habitual residence, and another issue is citizenship. That determine whether one is in-country adoption or whether one is inter-country adoption, right? So habitual residence is important. Suppose here anybody is adopting under HAMA, habitual residing, that is perfect. I think there was a question raised, so no issue at all. In case of inter-country adoption, suppose a couple residing habitually in USA or Canada, they have come and they want to take the child and go. So in those cases, they are not habitual residents of India. Further, they are not citizens of India. So they will face a lot of difficulties. Difficulties almost because they have to stay here, and they may lose the job. So NOC CARA doesn't issue in case of inter-country adoptions. They have to follow the JJ procedure, and even JJ procedure meant for relatives, stepchildren, or orphan and destitute children, right? Then eligibility and prospective of adoptive parents laid down under Section 57, and it has been broadly, it has been further explained in adoption regulations. Procedure for adoption by Indian prospective adoptive parents living in India laid down under in Section 58. Procedure for adoption by Indian prospective adoptive parents in Section 58. Then procedure for inter-country in Section 59. Then procedure for relative in case of Section 60. So relative means, you see, relative has been defined in, I think, 252. 252? Section 252. And broadly accepted, like there have to be broad relationship like uncle, aunt, paternal father, paternal uncle, paternal aunt, paternal grandparent, and maternal grandparent, something like that. So it has, and now we have quite a good number of adoptions of relatives within the country also under JJR. That is very interesting. And we have inter-country relative adoptions also. Court procedure for adoption laid down in Section 61. I'll come to that. Effect of adoption has been laid down. Section 63, that we are discussing. What is the effect of adoption? The documentation and other procedure requirement shall be as per adoption regulation. Court procedure. Adoption gets.
सर पीपीटी थांबली आहे बहुतेक ना केरलाकडनं
Sir,
PPT family, sir.
Jagannath, sir, are you showing the PPT? PPT
Yes.
is not PPT is not appearing.
Not appearing. One second.
Since 2 minutes back.
Okay, okay. Visible?
Yes, it is visible, sir.
Okay. And this is something what I told about the provisions of the JJR 2015 about dealing with the relative adoption, orphan and destitute children, and that I just discussed, and effect of adoption. Then court procedure. So if you see the court procedure, there are impression that adoption get completed with post adoption follow-up. It is not the fact. Adoption is complete with the adoption order. Adoption is not complete with NOC. Adoption is complete with the court order. Because sometimes I have also attended the other judicial academies. There was also question raised if CWC is doing and CARA is issuing NOC, then what is the role of court? Court is not a rubber stamp. So I responded like you see, court is the highest authority, and the final decision is made by the court, and court scrutinizes whether authorities and agencies have done due diligence, like whether there is a child welfare committee certificate declaring the child legally free, whether CARA has issued an NOC, whether there has been a child study report and a medical report of the child accepted by the parents, and whether there is a home study of the parents. So all these, when they come to the conclusion, yes, all agencies and authorities have played their due role, then takes decision in the welfare of the child. So only after decision by the court, then the adoption is completed, right? Then first of all, court means civil court which has jurisdiction in the matters of adoption and guardianship and may include the district court, family court, city civil. SA shall file the application in the court within 10 working days. In case the child is from a CCI, child care institution, linked to the SA, the CCI also becomes co-applicant along with the parents. A single petition is filed for twins or siblings. A single petition is filed for twins and or siblings. Let me just inform you that in such cases, we also issue single NOC. In case of twins and siblings, we also issue single NOC. And in case of Child Welfare Committee also, they issue LFA, legally free certificate, single certificate in most of the country, most of the places in the country. So in doing so, it shows that how authorities and agencies at each level are following, have streamlined the procedure. Then important issue, court proceedings to be held in camera and disposed of within 2 months of the date of filing. See, earlier what used to happen in the public, in the open court, adoption cases were hard, but with a lot of interaction and everything, and your training kind of thing. So normally these cases are heard in the chamber. Adoption orders should not stipulate execution of bond or making investment by the PAPs in the name of the child. So we have seen also those time when when adoption these judges, they used to order that in that particular locality you have to take 2,000 square feet land in the name of the child and deposit bond or something like that, about 5,000, 5 lakhs or 7 lakhs. So with such kind of, we had to intervene in the high court. We had to. So all the, I think nowadays this is uh, this is better. Now most of the courts we see in the country, they are not stipulating anything like deposit and also like any bond kind of thing. So it is happening, yes, without any trouble. Then, in case of inter-country relative adoption, the PAPs shall file an application in the district where the child resides. In case of, you see, in case of this or OS children, it is the jurisdiction of the agency where the case should be filed in the court. Then procedure before the court shall not be bounded by the procedure laid down in the CPC, Civil Procedure Code 1908, Rule 45 of the JJ rule. So what, we have seen a phase when in Jharkhand, around 50, 60 cases were delayed for more than 1 year. We had to get an appointment to the Chief Justice, and one particular judge, uh, he was issuing notice to the doctor who has prepared the medical report of the child, to the child welfare committee who has issued this legally free certificate, and to social workers and to the government, at least 10 parties, whoever they have as witnesses. So we could, we had a long session, and this was followed somewhere. But nowadays, now things have really improved, and there is no such case. And with the documents prescribed, and there are several documents prescribed in adoption regulations, and when cases are, filed before the court, and the court normally, I think in some of the cases, they dispose of in the first hearing itself. So this is what is happening, and in some of the courts, you'll be surprised to know it is within 1 week. They are just calling the parent and issuing and looking at the documents and just issuing the order. So things are becoming better and better every passing day. Then the application for adoption order is non-adversarial. Matlab, no, there is no contestant party. So the SA and the PAPs are co-applicant, and there shall not be any opposite party and or respondent. Then just coming to the section 61 of the Judge Act, I think yesterday there was discussion. This is the final, I think, the crux of the for the court for the guideline that they have to see the adoption is for the welfare of the child. That due consideration has been given to the wishes of the child, having regard to the age and understanding of the child. Like a child 5+, older child, the they can be they have been called to the chamber and they are found well adjusting or they are something. And instead of asking in such cases, instead of asking straight questions, it will be always better to have some kind of counseling, some kind of just involving the child uh, in a positive manner. And because when the child comes out, the child becomes with the may not interact with the strangers and the way the child interacts with the mother and father. So then that neither the PAPs have given or agreed to give, nor the agency or the parent or guardian of the child, in case a relative adoption has received or agreed to receive any payment or reward. Something like that. There is no scope such kind of thing that fees adoption demands of something like that. So there is no such. Now everything is structurized. Then because earlier before 10 years, what used to have happen in mostly intercountry adoptions, the foreign agencies and Indian agencies, they used to have working relationship, and when and they used to demand donations also, grants also. And in case of in domestic adoption, the agencies, they used to give preference to the people, affluent people, who can give donations. And there was no transparency, you can say ethical practices. So now with a central system, with pan India presence, now it has been regularized. The adoption proceedings shall be held. So comments, just a small comment on the how such things can be justified, the decision. Like welfare of the child, it may be a very broad kind of thing. Welfare of the child, that can be ascertained from the order declaring the child legally free for adoption, home study report recommending the suitability of the PAPs, and minutes of the adoption committee matching the PAPs with the child. Further, post-adoption follow-up is already, if there has been, if the court order is little delayed, and if there is a post-adoption follow-up report, that can be sought also, but it is not mandatory. So I think that is important. Then wishes of the child. If the child is above 5 years of age, I just discussed, so that can be worked out. No payment or reward has been, so that can be ascertained from the fact that the adoption process has been undertaken by the PAPs, duly registered in carings, and hence would not be paying. So nowadays the parents are also vigilant. If there has been any unethical demand from any agency, the parents can write to us and are also writing. So on this aspect, on ethical aspect like demanding money, so that can be understood if it has been done through carings and online system, through CARA procedure. Then I think such cannot be an issue. There is no requirement of a scrutiny. One more important issue: uh, states are uh, still demanding scrutiny by ICCW and ICSW. We have written a letter to the Registrar General of Bombay High Court, I think Karnataka High Court, and Tamil, something two, three. You see, scrutiny was required at a time in case of guardianship orders by ICCW and ICCW, and that was a direction by the Honorable Supreme Court of India in case of Lakshmikant Pandey versus Union of India. Because those are guardianship cases, and because even the CARA was not involved at that time. So as a scrutiny ICCW branches, they used to work as a friend to the court. But now there has been sea change. Now nowhere that ICCW, ICSW are required, because they do not have any, except particular courts. They do not have any sanctity of this by through JJ Act or JJ rules or adoption regulations. Say there is no need of scrutiny of by ICCW and ICSW. They are charging scrutiny fee, and also they get delayed another 15 days. When we talk that even one day of a child is important, and the child should be institutionalized, deinstitutionalized, so such a procedure can be avoided. So about the scrutiny, and if there will be question, I would be responding to all of you, but let me just cover complete. Then order sought for the parents. See, just to enable that, the court order is the vital document that is required for the passport, that is required for any benefit for the child, for child care leave, for anything, for even adoption leave. Then adoptive parents declared parent of the child for all purpose of the law. The new name as given by the adoptive, there is scope that the prospective parents may suggest in the petition that my child may be known as this. If they have given an option for a name of the child, so usually that is written, and it may be recorded along with the date of birth of the child, because in the court order, whenever there is a discrepancy, anything, so we always check what is the date of birth in the court order. So we always give priority to the court, what the court order is, and what is the date of birth in the court order. So therefore, in the court order itself, the parents have to be written as parents. They can be the date of birth of the child can be written so also, and the new name that has been given to the child can also be mentioned. Directions may be given to the birth certificate issuing authority to issue birth certificate within 5 working days from the date of receipt of the application, with the child's name as requested by the adoptive parents in the application, the date of birth, adoptive parents as parents of the child. No more. Once the court with the court order, they will be named as adoptive parents as parents. So their status will change from the date of the court order, and it should not be mentioned the child is from so and so Sa, and the place of Sa as place of birth. No, it can be written for as a town or city. The child from Pune, from Nagpur, or from any other place. Because if they in the birth certificate, in the court order, it is mentioned, and if it goes to the school, submitted to the school, submitted elsewhere, so what will happen? There will be some kind of stigma, because not even the schools and everybody, we have not been able to educate everybody about how there are still misinformation in the schools, in the institutions. So with all this, these are all provided in the adoption regulations. Then attested photocopy of the child affixed in the court order. Normally, we have seen the photocopy of the child is affixed in the court order. Then now I'm coming to some of the case laws present, and so I think this will be interesting. And we have I think the most important judgment was Lakshmikant Pandey and Union of India. Then subsequently we have several orders important from the Bombay High Court, Justice Chandrachud, Justice Patil, then Justice Chandu from Madras, Justice Basant from Madras High Court. Then we have a lot of directions from time to time, even related to passport, even related to right of the child. So what we have all combined, incorporated in our adoption guidelines from time to time and adoption regulations. So almost you can say we have, these are all related to safeguards of children. We have included now adoption regulation, I think complete. We have included almost everything. Anyway, I will give some, go to some court cases where I think you will get to understand. See, this is about related to territorial jurisdiction. Territorial jurisdiction. You see, the child was found in Muzaffarpur, and when the child was transferred to this some other Darbhanga, and when Darbhanga agency applied for the court order, and there was problem created. The case is Salu Kumari, in the name of Salu Kumari. In the present case, apparently, the petitioner Shah is located within the territorial jurisdiction of the learned court where the application has been filed. Though the child Salu Kumari was found abandoned in another district, Muzaffarpur, and was initially placed in the care of another Shah at Muzaffarpur by the order of the Child Welfare Committee, but subsequently by order after cancellation of the recognition of the said Shah Muzaffarpur, the Child Welfare Committee Muzaffarpur directed the transfer of the child Salu Kumari along with other children to Darbhanga. The Learned Family Court Darbhanga, while recording the finding on territorial jurisdiction in the impugned order against the petitioner, has apparently been swayed by the only fact that the child was found abandoned in the district Muzaffarpur. Normally, see, the impugned order of the Family Court Darbhanga is erroneous and not legally valid. So, in the sense, the High Court, it emphasizes as per the adoption regulation where the child can be brought from another district. So, it is not important. As far as the child should be declared legally free for adoption, after the child is declared legally free for adoption, the child should be transferred. Normally, it should be, this is called healthy practice. And the advertisement should be issued in such places where the child was found for the first time. So, in this particular case, actually the district where the Shah is located and the district where the court is located, and that is the place where the case has to be filed. I am coming to another case. This is by Bilaspur, High Court of Chhattisgarh at Bilaspur. So many cases were pending and for a long time, and the court has given a lot of guidelines about the role of CARA, and if how things should be disposed of, how a particular case is non-adversarial, like there is no contestant party, while deciding an adoption case, the court shall strictly adhere to Rule 45(2) of the Model Rules, Adoption Regulations, and the JJ Act, Section 61. So this is an important court because whenever there has been pendency, though, when a matter was referred to the High Court, High Court issued a clarificatory order and for instruction to the all courts within the state to expeditiously process the cases. Like this is since an adoption case is all with an application for adoption, names and details of the pub shall be kept. In a case of inter-country adoption, it is mandatory to complete progress report on quarterly basis during the past year and on a 6 monthly basis. This is all provided in adoption regulation. But the court in a circular issued a direction kind of thing to all subordinate courts. I'm coming to something about this Binita Kuswa case that was Madhya Pradesh High Court principal bench at Jabalpur, and this is something there was delay by the CWC and the courts also. See, this judgment explains not only the functioning of the court to exercise the jurisdiction in adoption case by the court concerned, ensuring early disposal of the adoption cases, but simultaneously the functioning of CARA, CW, SARA, and SA. I'm coming to this another this mandatory requirement of NOC from CARA. That is Honorable Supreme Court requirement of NOC. No, mandatory requirement of NOC in case of foreign citizens residing in India. Karina Creed case. Justice Indira. So the fact of the case is that the Australian citizen residing in India wanted exemption from that. Normally, the procedure is like that because CARA and India and Australia are Hague countries, and they have to, follow the Hague Protocol. So, in such a case, they wanted without issue of NOC, they can proceed. But it was stipulated. It was because they have to, the foreign citizens in India, they have to get NOC from their mission, their high commission or embassy. So that is already there. It is also provided 59, section 59, clause 12. Section 59, clause 12, that a foreigner or a person of Indian origin or an overseas citizen of India who has a habitual resident in India, if interested to adopt a child from India, may apply to CARA for the same along with a no objection certificate from the diplomatic mission of his country in India. Suppose Australian mission, Australia High Commission, they have to have no objection or further necessary actions as provided in the adoption regulation. So therefore, so that is required, and that was directed by the court, and the case was dismissed. Without because there was no compliance accordingly, so that case was dismissed. Then I am something directions for adoptive parents to take back the deposit and the right of adopted child to inherit the property. So this is, I think, in Calcutta. We are discussing about the deposit. So district judge, this was imposed by the district judge, and the matter went to High Court, Calcutta. And the adoptive mother says that there was, I think, 50,000 rupees deposited. It is made, the final order came like this. It is made clear that the letter of the bond that may have been furnished will not be binding on the adoptive mother. The further condition imposed by the order, impugned of the child being produced at regular intervals before the district judge, is set aside. The district judge asked to produce the child at frequent intervals. There is no such system as per the Act and as per the adoption regulation. And also the sum amount that has to be, the amount to be taken back by the 50,000 rupees that was deposited. So that has to be taken back by the parents. So I think the issue was discussed about the deposit. So there is no issue of imposing any deposit. This is by Calcutta High Court. Then something about Honorable Supreme Court of India about inter-country adoption to be scrutinized by an expert committee. In the year 2010, there was a case, I remember, older child, and it was adopted by American citizen and she was around 55 or something, 50 plus, and she was a nurse, practicing nurse. It was it was rejected at the by the High Court also about the case. The matter went to Supreme Court, and the Supreme Court set up an expert committee through AIMS, chaired by AIMS professor, and ultimately the child based on their report, the child was allowed to proceed. And in that direction, the Supreme Court of India also directed that similar committee should be there at CARA and at a state level also. And we interestingly we are having this expert committee to issue NOC, you know, in all cases of inter-country adoptions. So that we are following that our NOC committee has the head is headed by a professor of AIMS. So this is interesting. Then there are some other important cases, like not recently, but I would like to just you know come bring before you, because it was in the year 2009, Justice Chandrachud, in the case of Payal at Sarin Vinayak Pathak, High Court of Judicature at Bombay, adoption petition 31 of 2009. So it was interesting. There was the debate on Hama and JJ. So Honorable Court directed that Hama is a general law for Hindus. Hama is a general law for Hindus, while JJ Act is a special law for special subclass of children, that is orphan, abandoned, destitute children. And this is like Hama and JJ Act must be harmoniously construed. The Hama deals with conditions requisite for adoptions by Hindus. JJ Act, it was not the JJ Act 2015, JJ Act 2000, a secular law enabling rehabilitation of orphan, abandoned, and surrendered children through adoption, would prevail over Hama, a personal law that has placed certain restrictions. So it is a very good interpretation for even for academic purpose. It should be read even before commencement of JJ Act 15. The kind of spirited the judgment was referred in many training programs. This judgment of it was very interesting. Then one case, adoption petition must be expeditiously disposed of. This is again from the Bombay High Court. There was delays in the court, at the level of district and family court, and so the delays, the matter went to the bench of Justice Jain Patel and Justice Roshan Dalvi, and see the spirit of the order. Any delay on the part of any authority, including the judicial officers, results in delayed bonding with their adoptive families, and consequently their overall welfare is prejudicially affected. The court taking adoption petitions shall only consider the financial and cultural background of the adoptive parents and the NOC of CARA when disposing of adoption petitions. All such petitions shall be disposed of most expeditiously. So a number of court cases of inter-country adoptions were disposed of. Something about adoption and guardianship issues must be expeditious. This is also about Justice Chandru has given in Madras High Court, has given a number of pro-adoption judgments. Very interesting. It can be searched. So I am just quoting one of them. See, there were, I think, large number of court cases pending all over the state of Tamil Nadu, and with a single order, At a time, all cases were cleared and instructions were passed. This is very interesting. In most of the guardianship and adoption issues, there is hardly any contesting party, and the paperwork is largely done not before the court but by the registry and the other agencies involved. Therefore, there should not be any delay in processing such uncontested matters and giving an expeditious disposal. What a interesting order. Then we are discussing about the confidentiality, and now there is a on something on the confidentiality. Even Supreme Court has said about the dealt about the confidentiality, and this is about Bombay High Court Criminal Writ Petition 1502 of 2010. The information regarding the biological parents of the petitioner cannot be divulged on account of the confidentiality agreement, which is binding on the recognized adoption agency. That means when there is in the adoption affidavit or something will be done before the CWC, Child Welfare Committee, if the parent, biological parent, onward mother, whoever, wants not to be connected again, I think she cannot be because she wants to remain anonymity. So in that case, the root search for the older adoptee will be difficult. Then some of the court cases and some of the best practices. Some of the best practices I would like to emphasize that during COVID, you see, it is very interesting. Even the adoption agencies, they are taking the child to the state headquarters, to the state capital, and seeing off their child to the adoptive parents, because inter-country adoptive parents, they are waiting and waiting for several months, and they have managed to come to the state capital level, not to the to where the child is located. So accordingly, we have also asked the agencies to proactively see that there is no unnecessary harassment to foreign prospective adoptive parents. So they are going to the state capital and they are handing over the child. So this is and during COVID, most of the things on virtual media basis we have been able to handle. So also we are getting cooperation from state and the child welfare committee and the courts all over the country. I think this is the best practice. And another best practice we have seen that there is a provision that within 24 hours a child has to be produced before the CWC. But we see a tendency that even child welfare committee, they are visiting the agency and looking at the child instead of the other way, to just to create, not to make harass, because the child reaches in the adoption agency in a difficult situation, and the rather for the safety of the child, child welfare committee members do visit the child instead of asking the agency to produce the child before them. So this is going fine. And another one aspect we have found that court is clearing the cases in the first hearing itself. In some of the court cases we have seen in India, it is really marvelously. The time is it is taking no time. Then counseling efforts by DCPO SA for rehabilitation of older children. See, we have a challenge there are two challenges, you can say. Challenge first one is challenge of rehabilitation of older and special needs children, because there are disruptions also within country, and their counseling need is very important. Counseling, and the other challenge is that many children are not reaching adoption agencies. We do not have figure. They are not reaching adoption agencies, and while parents are waiting and waiting. So this is something challenge, I think, that we have to adhere. But some of the cases with the counseling efforts, we are able to handle adjustment issues with the older children. Before few years, I remember 4-5 years, Damo है ना, Damo, ना? Damo, a place in Madhya Pradesh. There were about 60 children in the age group of 6 to 8. 60 children in the age group of 6 to 8, and the children were not interested to leave the institution. The agency was getting donations, foreign donations, and not interested for their adoption. So with our rigorous effort, with counseling, and we called their social worker, we went there, we sent DCPU, then CARA, and we could, out of 100 children, we could place around 60 children, 60 children in adoption, and successful adoption. So that is what I think our best practice is. But we have to work more and work hard because at ground level there are still problems. Then something about large number of capacity building activities by state and CARA. It was not happening earlier, but nowadays, since last few years, after JJ Act, JJ rules, ICPS, adoption regulations. So we are having, I think nowadays, whoever coming and participating, they have some ground knowledge of child rights and child protection issues. So that is interesting. Even we have child ombudsman bodies, child commission at the state level, district level. Whenever there is a case of, we get some report from anybody about child abuse, something, we involve the state government. And but the issues are very less. And what I just would like to reiterate that the challenge in our adoption system are older and special needs children, and also many children are not reaching, in the adoption loop. So those are two challenges, and something I would expect that since we have CWC members participating and learned judges are participating, I would like to urge them, request them that that whatever be the case, if everything you are satisfied that the child is going to a right family, then then I think that you can take the decision at the time itself, at the first hearing itself. So that will help rehabilitation process, and a child rehabilitated early. And that is what everybody wants. That is, a child should go to a loving and caring family, and at the earliest, it should leave the institution. Now, I think so. These are some of the slides. Now we can discuss, have the questions. If allowed.
Yes, sir. Thank you very much.
This time, okay. It was clear or not audible?
No, this time very clear. No problem, sir.
So we can have sir questions, as many as questions.
Yes, sir. Yes, sir. Before starting the question answer session, I would like to bring to the notice of the participants about the importance and the delicacy in dealing with the applications by the district judges. A few years ago, when Mrs. Maneka Gandhi was the concerned minister, there was a proposed move to change the forum from the district judge to a district magistrate. I think Jagannath Pati sir can recollect it. The reason was that there was apprehension, maybe well founded or not founded. There was an apprehension that the much delay is taking place in the district court in this final process of this adoption. So in fact, my intention in pointing out this is to sensitize all of us that these applications should be these applications before the district judge should be dealt with as if possible in one sitting. I can tell you, even in the Honorable High Court on original side, when these matters are placed, normally they are disposed of in one sitting. In very rarest of rare cases only the parents are again summoned. So what we hear in other cases, तारीख पे तारीख यहाँ बिल्कुल नहीं होनी चाहिए यहाँ पर. So probably this was the the delay here was the reason for the proposed move by the then Honorable Minister Mrs. Manika Gandhi. So just it was probably it will be an eye opener for us. हम अगर इस तरीके से कोऑपरेट नहीं करेंगे, आगे स्विफ्टनेस से काम नहीं करेंगे, जैसा ट्राइब्यूनल्स बना के बहुत सारे मैटर्स रेगुलर कोर्ट से इतर कोर्ट्स को चले गए हैं, तो ये भी मैटर जाने वाले हैं. तो यहाँ पर मुझे लगता है कि डिस्ट्रिक्ट जजेस आर द प्रॉपर पर्सन्स. कुछ ऐसी भी बातें हैं कि यहाँ पर डिस्ट्रिक्ट मजिस्ट्रेट नहीं कर सकता वो काम. ऑफ कोर्स बाय लेजिस्लेशन हो सकता है, अदरवाइज ये काम जो है यहाँ पर वो डिस्ट्रिक्ट मजिस्ट्रेट से नहीं हो सकता है, तो इसलिए डिस्ट्रिक्ट जज के पास ही रखा गया है. गुड थिंग. I wanted to draw the attention of the honorable district judges who are having applications pending since months. I'll talk about months also. There are some cases from since last year also. It should be a matter of concern. So that's my humble appeal to the honorable judges to pay attention on day-to-day basis to these matters. Ensure that these applications are disposed of. I don't think that they can be kept pending for more than 1 week, or at the most 1 month will be the highest one, unless there are some other compelling circumstances like appeals or certain orders are there. I think Jagannath, Pati sir, do you recollect that move?
Yes, I was very much here.
Yes, sir. So I think this will help us in making us conscious. Now I will take the queries from the participants. First, I will take up the queries from the charts which remained before our interval. One question, though it appears to be general question, I would like the honorable guest speaker to briefly deal with it. What is the role of CWC in placing the child in pre-adoption foster care before the court order? You have dealt with, yesterday also this was dealt with. Sir, what is the role of CWC in placing the child in pre-adoption foster care before court order? Briefly, sir.
Yeah. So actually, JJ Act and JJ rules, we have been involved also in the consultation process, everything. It has been done in such a manner that each agency has a particular role. Each agency and authority has a particular role. Like SA is responsible, adoption agency is responsible for quality child care, for preparing child study report, for preparing this assisting the things to CWC. As far as CWC is concerned, their job starts with the child and ends with the child. That means they play a very important role as far as separation of a child is concerned, because CWC is the competent authority who can separate or declare a child as abandoned and declare a legally free for adoption. So it is up to the Child Welfare Committee. This responsibility has been assigned. But as far as pre-adoption foster care is concerned, it is something else. It is District Child Protection Unit is involved. The adoption agency is involved. So therefore, there is no role as far as pre-adoption foster care is concerned. And Section 62 of the JJ Model Rules defines the role, duties of Child Welfare Committee, Child Welfare Officer, or case worker. Duties of Child Welfare Officer and case worker. So, as far as pre-adoption foster care is concerned, the role is quite defined that adoption committee will take decision.
Thank you, sir, for refreshing this aspect. This is very important since we are addressing the members and the chairpersons of the CWC. A very brief intervention. My brother Aniruddha Tikle wants to share on foster care. Sir, please have not more than 2 minutes intervention. Aniruddha Tikle, sir, please.
Yes, sir. Am I audible, sir?
Yes, sir. Please go ahead.
Yes, sir. I want to say something about the foster care agreement. Now, recently, Dr. Pati said that there is no role for CWC in while putting the child in foster care agreement. Now, last year I came across one news item that almost 70 children were placed in wrongfully in adoption. Now that in that matter, Bombay High Court passed an order. Now one matter is also pending in our bench, and I don't want to diverge on the merits of the case or allegation. Recently, I am dealing with such a matter. Now, what happened? Some specialized agencies are just giving for children in foster care agreement, and they just don't upload the information about the same in carings. Almost, I have come across almost 30 such order that without following the process of online procedure, the children were given a foster care agreement, and then even adoption orders have been also passed. So I want to say that there has to be either greater role to CWC, its role should stretch till the child is given a foster care agreement, or there should be advancement of role of a court that a child should not be given a foster care agreement without intimation to the court.
Can I respond?
Yes, sir. Yes, sir. Please.
Yeah. See, we are already having few cases where CWC have directly placed, not a DCPO, not agency. We don't have a single case where SA has placed in foster care. Rather, the child welfare committees, they have placed orphan children in foster care, in adoption. So that is in Maharashtra also, in other states also. We are contesting that. So let me just tell you, if any adoption agency is doing foster care in such a way without, following due procedure, then it should be informed to the CARA state and CARA. Action can be initiated against them because our system is very transparent and we check how the things are happening foster care. And there is any particular grievance, if you share with us, we'll be more than happy to handle that.
Thank you, sir.
Yes, please.
Sir, there is a query which is apparently relating to Hama, but it is not actually relating to Hama. The question is, I will put it as appealable to you, whether CARA can issue a NOC to a Hindu residing abroad intending to adopt a child under Hama, because the authorities insist for NOC from CARA.
Which authority? That's
for foreign authorities.
Yeah. We cannot issue any NOC under Hama. It is clear. Only under JJ, only the procedure followed under JJ, we can issue NOC. It is absolutely clear.
Thank you, sir. My brother just says that having the less pendency in family court of most of the district and object of family court, is there any possibility of a policy decision about filing the adoption cases only in family courts? A little while ago, I discussed that the ministry wanted to shift the forum from the district court to the district magistrate. Now my senior brother judge is suggesting that is there any consideration that
I think that may be decided by the High Court as far as jurisdiction is concerned, because in some of the states family courts are hearing. In earlier there used to have a very limited family courts. So in the case of Odisha, I will tell you that only 2 family courts were there. Now every district has a family court. So I think there should be no issue, either family court or district court or city civil court. All courts are can handle.
Thank you, sir. You have pointed out that the Honorable High Court can take a decision. Now the queries in the charts are over. Now I request my brother Judge Sri Thorat to invite the persons from the participants who raised their hands.
Sir, Mahesh sir, unmute करून बोला ना please.
Yes.
Good afternoon. One question which I faced in this COVID lockdown is that the institutions which are dealing with adoption cases, they're not having their registration continued. One email I got is that some of the institutions have applied for their recognition continuation, and for few months, 5 months, such authorization has been given to the institutions. My question is whether the CARA can monitor this issue to avoid the delay in deciding the matters.
Okay. Okay. There is a procedure and laid down procedure that where SA, Specialized Adoption Agency, is defunctional or is waiting for license or anyway in an interim phase, then in that case, DCPU has to file the petition. DCPU has to take lead concern. DCPU concern district.
Yes, sir. Thank you, sir. Swaraj sir, please.
हा मलावदे साहेब आहेत सर.
Yes, sir. Malabar sir, please unmute and speak. Malabade sir.
सर प्लीज अनम्यूट करा ना. नंतर शबनम खान मॅडम आहेत.
Hello.
हा बोला.
Yes.
Hello.
Yes, Shabnam ma'am.
Am I audible?
Yes,
Yeah,
you're
am I audible?
Yes, ma'am.
Yeah, this is Shabnam Khan, CWC for North Goa district. We had a very peculiar case before the CWC when I joined 2 years back. We had a case of an illegal adoption wherein the parents had illegally adopted a child and they left in the care of their family and they went back to UK. Now, this family thereafter did not take care of this child because they were around 60 or 65 plus age group of people. And they finally gave the child to another teacher to take care. And this child happened to be abused and tortured with the teacher. And finally, this child was through VAU and it came into our system. This child was placed in a CCI. And thereafter, the same family who was given to be taken care of appeared before the CWC for application for foster care. So after due deliberations and the reports, the CWC came to a decision of not granting permission. The child was of an adoptable age, and also the parents did not fit into the criteria of. Now, these same parents went in appeal to the district magistrate, since the magistrate is a grievance redressal authority for foster applications, and the district magistrate herself dismissed their application for fostering and gave a direction to CWC to declare the child as legally free for adoption and continue with the process of adoption. Simultaneously, the child was legally declared legally free for adoption. In the meantime, we also secured the parents of the child who were not traceable through the women police, and we secured their surrender deed also. And the whole process happened of adoption. She even got parents. The child was very much keen in going to the parents, but from nowhere, these foster parents again went against the order of the bench in Goa, Bombay bench. So now this matter is just pending in the High Court right from the lockdown period. And this child is very much keen in going back to the parents, and the parents are waiting, the adoptive parents are waiting for the child to come in their system. Now, I don't understand what is the role, how are we supposed to deal with this? You know, it's a very classic case to us too. Can somebody just throw some light on this?
Yes,
Actually,
Jagannath, Pati, sir.
Yeah, the matter is pending in the High Court now.
Yes, exactly. It's more than 8-9 months now, right from the lockdown period.
Okay. I think you tell us if you send us details, we can write also intervention letter to the Registrar General of the court, and that is one thing.
Okay.
That is one thing. Number two, in this particular case, CARA has given already NOC.
Yes, has been given.
Okay, so we'll take care of that. We'll definitely
Thank you so much.
Pursue. Please send us detail. You can send my email. You can directly write
Yes,
to me
sure.
about the case. So we'll write a formal letter
Thank
to
you so much.
Mr. We'll do that.
Sir,
Thank you so
thank you very much.
Thank you.
Thank you very much. By answering this query, you have opened a helpline to our judges. You have informed that, in fact, the judges should take the advantage of these services from the CARA in case there is any problem. Thank you very much, sir. And now I
नाहीये
request.
सर, हँड रेज नाहीये.
होते एक जण होते.
नाही सर, गेले ते. आणि चॅट मध्ये आता 27चा एक प्रश्न.
मलाबाद सरांचा दिसतोय हँड रेस बघायला.
Yes,
नाही
Malabadi.
सर.
Yes, Malabadi sir, please make intervention. Unmute yourself.
नाहीये सर. अगरवाल मॅडम होत्या.
Good afternoon, sir.
Yes. Good afternoon, sir.
Good afternoon, sir. My query, by way of suggestion, can it be possible to obtain insurance of the child? Because we don't know what happened on tomorrow. Only it is for the security of health of the child.
Yes,
Yes.
sir.
You are
Yeah.
talking about insurance for the child?
Yes.
Sir.
See, there was a discussion on the issue before few years. Some medical insurance should be there, but it has not been finalized so far. While we are, we have our adoption fee structure, we are also finalizing utilization, how they can be utilized. So in that case, we are making provisions for all medical emergency, for everything, so that we are getting feedback from the states. Once feedback from the states is complete, then it can be they can be addressed. As far as medical insurance is concerned, so we try to contact also the insurance agencies just to have more knowledge about this, but practically nobody came forward. So because the child will be for a temporary guardianship with somebody, with the kind of situation we try to convince them, but no agency came forward to, because we have to adopt it all over the country, not a particular agency. So that just dead away this. So maybe once we define this, adoption fee utilization, that will help them, because
Sir,
the agencies.
I will expand this, sir. In fact, we discussed this some years when we had this kind of discussion at the National Judicial Academy. The faculty members were there at that time with the CARA, then Deepak Kumar, CEO. Sir, maybe we had a point. Now this time also, if as a district judge, if that matter is pending me, if I as a district judge, if I ask the parents to have a little some policy at least. Now I can give one example. If you open a bank account in a national bank, there is some general insurance policy which is available with a very faulty amount. So that kind of insurance may not be a medical insurance, but it covers some, at least some accidents, etc. I think that. So I think if I as a district judge, if I ask those parents to buy at least that petty policy, so will it be wrong?
Actually, this will set a precedent also. The others, they will do all over the country, all over the state. So what will happen? Actually, nowadays, before 5 years, it was happening some of the places. But with our intervention and with the request and with the JJ Act and kind of regulation, see, we are having a lot of safeguards we are getting post-adoption follow-up. Because once adoption order is complete, the court job is complete. Then comes a headache on the CARA, post-adoption follow-up for 2 years. Then we are monitoring and the state is monitoring. So till that time, I think if we use stipulates, because it can be then in a particular case, it is okay. But if it is done in all cases, it will again invite problem. What was happening earlier?
Sir, I beg to differ with you because, sir, before you are right, sir. before adoption order, especially during the foster care, you must have come across some cases also. When the child, even recently, yesterday also, one sister judge from Goa shared that the child was in foster care, and when the child was produced through online, she noticed the injury on the lip, and she inquired about it, and she was told that that child slipped in the bathroom and got that injury, and she was apprehensive of something untoward. So the different aspects. That's only minor thing. And in one of the cases which was shared by our judges at that time, the child all of a sudden accidentally fell down and got this brain damaged. The question was, you are saying that CARA before or after the order, CARA before the order, this SARA will be there, and after this order, CARA will be there. Sir, definitely you will take the follow up, but the question will be, who will bear the expenses of that child? What will happen if those parents cannot afford to those expenses? So if I'm asking, I'm not asking for bigger policies, cashless hospital policies. I'm just, as a district judge, if I think, if I know as a common man that if I open a national bank account, I have the facility of getting insurance, general insurance with a policy amount of one policy is there of 12 rupees something, and another policy of some 3 digits. So if this kind of orders are, may not be insisting, but what's the wrong in asking for that kind of insurance?
See, the regulation or the law doesn't support that, but because why it is so? Because there is a child protection service everywhere with the DCPO. If there is a abuse or neglect even by adoptive parents, there is a system of reporting and to take care of the situation. We have also situation that we have withdrawn the child from a parent, but this has hardly happened because in our society kind of thing, once the parents they have option also to return the child to the parent adoptive to the adoption agency, and we have seen and through counseling also we have addressed, but stipulating financial criteria, it can be case by case, because why we do not want from CARA side, because suppose I am getting, suppose somebody's salaried job, and if a judge says that in the area you have to deposit certain amount, where income tax, where he has to get such kind of manage that kind of amount, it will not get a again a good precedent again, because earlier what used to happen, the parents used to cry before us, a particular judge in some of the places, they are asking in this particular area you have to take a 2,000 square land, and 2,000 square feet land, that comes about 20 lakhs. So 20 lakhs you have to take.
Sorry for the intervention, sir. Our discussion is only on the medical expenses, sir. I'm fully convinced. I don't pass any such order as a district judge. I'm only concerned that you said that CARA will take care, restoring the child, taking back the child, everything's okay. But my genuine query is that, what about the medical? Who will bear the expenses of that child? How
The
that child will
parent.
get the treatment?
The parents, they are capable. If the parents, I think there is a trust also. Adoptive parents, their home study, their everything. There is a trust also that the adoptive parents, they are supposed to take care of the child, and normally it happens within the family. So they are supposed to take care of. If they do not do, the question is, if they do not do, that can happen with the biological parents also. Biological parents also neglect. So in that case, what we do? We call the child protection service. We take childline takes, with the help of childline, we take custody of the child again. So it will. What I can say in summary, our regulation and act do not support this. Baki, rest is your privilege, sir.
Sir, I'm trying to understand, sir, but my brother and sister JS have probably similar queries. Again, Malapati, sir, please briefly, sir, don't make it as a debate now. He has concluded that. Just
Yes,
Malapati,
yes.
sir, just in 1 minute.
Yes. Sir, my suggestion is that if the child is in the custody of CWC, then that custody is to be treated as the custody of government, then why the government should not to obtain a health insurance of that child?
Actually, child is see, we tried from our side to have a to opt for child medical insurance for all children. So there were conditions were very so that we can issue directions to the state government also. But we found the conditions were not conducive and they did not agree also. And for the as far as see, the child is staying say 4 months, 6 months, 8 months with a child care institution, that again is a larger issue. That is a child protection issue. So the state government, they are free to do anything that they want to take care of the child, because child protection issue is the prerogative, is the responsibility of the state government. They can find any way. No controversy on this.
Sir,
Because
unmute sir, mute kara.
the child is the word of the state.
Sir, unmute kara na please.
Now I invite Kavita Agrawal ma'am to unmute and make the intervention. Yes, ma'am. Agrawal ma'am.
Yes, sir. I am
Please.
audible.
Yes, ma'am. Yes, please go ahead.
Sir, I have joined today itself. So my query was whether the inter-country adoption, in cases of inter-country adoption, whether we can ask the parents to stay at least for a week with the child before taking away it in the foreign country after our order.
Yes, ma'am. See, I would like to respond. Yeah, see, the parents normally come, foreign parents normally come much before the court order, because they have to mingle with the child. If they suppose they have just come a day before, in that case it is fine.
Okay.
If they have already come before before few weeks and already spending time, because if we stop them, because they plan their flight in advance, they take their job, they take a leave, and extending leave is not that easy, just like India. Then there are some other passport, visa, exit visa, conformity. There are a lot of issues together. So, in my point, what I feel, if they have already spent time, then it is okay not to stipulate to stay some time, because they are bound to, once a NOC, they come much before the court order.
Thank you, sir. Again, I think Anaga Rote madam wants to make some intervention. Yes, madam, quick intervention.
Sir, so far as that insurance point is concerned, I just wanted to add that we are not making any stipulation or making any force or any condition on the parents. If they are voluntarily willing and if it is suitable for the welfare, ultimately paramount consideration is welfare of child, then why not?
Yes,
why
see,
not?
once the child is adopted by them, and they can do whatever, like any package, any medical insurance, anything, they can do in favor of the child, because that is with a court order. They are biological parents. They are as good as biological parents. Before that, they are not. But once they get a court order, they are complete. Their status is they are biological parents. So, being a biological parents, we have the authority to keep any insurance or anything do for our child. So they are entitled to. And
but one should not forget that we courts are also equally vigilant enough to take the welfare. Yes. Sir.
I'm sorry to intervene. I think I said
yes. That point is open.
Yes.
Okay, yes.
Yes, we will not debate on that.
Yes, sir. Yes.
He said that case to case we should understand, but we will not make it as a mandate which will go to the extent of rewriting the rules itself. I think I understood it that.
Yes.
Thank you. Now I will take the question from whether from a judge, my brother judge, whether pre-foster care agreement is required to be executed before the court or required to be approved by the court. Pre-foster care agreement. Pre-foster care, the court will not come into picture, sir. pre-foster care agreement is to be executed before the court, or it is to be approved by the court? That is the question, sir.
सर त्यांनी म्यूट केलाय म्यूट माईक.
Yes, Jagannath Pati sir, unmute
Yes, sir.
please. Yes, sir.
Yes.
Did you get the query, sir?
1 minute. Yes. Yes, yes. Hello. Can you hear me? Can you hear me?
Yes, sir. Audible, sir.
Okay. See, pre-adoption foster care. There is a nothing like a pre-adoption, not before that. It is
Sir, pre-foster care. Pre-foster.
Why I say pre-adoption foster care? Because there is a difference between pre-adoption foster care and pre-foster care. Pre-foster care means temporary foster care, just like a CNCP children. The foster care services done by the Child Welfare Committee and the DCPU, that is depending. This is pre-foster care. That means adoption se pehle. Matlab, they are adoptable children. So in that case, even whatever, that is not to be signed before the court. That has not to be signed before, even if a notary public, that has to be done. Pre-adoption foster care.
Thank you, sir. Now I request Honorable Sri Mahajan sir to make intervention. Kindly unmute sir and speak. Mahajan sir.
Yes. Sir, in
Yes,
the
sir.
operative order, direction is required to the birth certificate issuing authority to issue the birth certificate. My question is, which authority of which place, where the application was filed or where the adoptive parents are residing are supposed to be mentioned?
Where agency. Yes. Where the child, suppose take the district Pune. In Pune, the adoption agency is there, and the child is also remaining there, Pune. So the court has to issue the order for this that located in Pune only. There must be birth registering authority, municipality or whatever. So where the child is located, birth certificate has to be done from there only. Because even if you write that simply the birth certificate authority is directed and the court will send the copy, and sometimes in case of inter-country also, it has to be written about the passport to be issued in that case. And section regulation 36. Regulation 36, that is birth certificate issuing authority. Yes, deals with the birth certificate issuing authority. So it has to be to the child, to the place where the child is located.
Thank you, sir.
Okay,
now, in fact, I expected more queries from the honorable members and the chairpersons of the CWC, because they have the greater role in this entire process. I have a query from Pune, Savita Patale ma'am. She says, we find difficulties in dealing cases of mentally ill mother. Probably she is speaking about the biological mother whose child is likely to be given in adoption. Mother is mentally ill.
Yes.
Question may be, probably the query is whose consent has to be taken.
So there is provision in the JJ Act also. I'm just trying to get the point. See, in case the mother is mentally ill, so it has to be certified by the medical board, and the report has to be submitted to the Child Welfare Committee. And if the mother is moderately or in a position is curable, then in that case the the child cannot be declared legally free. But if there is a condition that the, the mother is challenged and is unable to take care of the child, so in that case, the Child Welfare Committee, in the interest of the child, can declare the child legally free with the supportive documents from the medical board.
Thank you, sir.
सर हँड नाही रेज कोणाचा सध्या तरी.
Sir, there's a request, there's a query whether this study material regarding the adoption can be sent by email. Yesterday, I would like to inform that as per our request, yesterday's faculty members have shared their PPTs with the Maharashtra Judicial Academy. We have withheld them because we wanted to include today's materials also, and we will share them through email to you, the participants. Definitely, we will arrange for this.
Okay, I will do it.
And if you people are interested, again, if some of you have missed it, we would like to inform that these sessions which are recorded, they will be uploaded to our YouTube channel, and the other judges and even you people also, if you have missed due to some connectivity problem, you can again watch them. It will be useful for all of you. So this is the information which I wanted to give. Sir, Jagannath, Pati sir, you are muted. Any queries? I don't think we have left any queries.
नाही sir.
Sir, Jagannath, Pati sir, I would like to inform that it is very matter of pleasure and glad to inform you that in yesterday's and today's sessions, we had near about, I think, 4 or 5 principal district judges. What else we can have? When if the principal district judge takes initiative and gets acquainted himself or herself with the entire procedure, and as I was saying that the process of adoption can be completed within the time schedule. I salute to the honorable PDJs who have taken interest and participated in this program. Sir, any concluding remarks? I would request the honorable principal district judges to give some conclusive remarks if they can. Sir Mahajan, sir, may I request you to give some remarks? Honorable PDJ Mahajan, sir.
Yes.
Yes, sir.
Honorable Jagannath Sahib, Honorable Jagannath Pati Sahib, and all the participants. Since last 2 years, I have been conducting the cases of adoptions. Near about 60 cases have been completed by me and disposed by me. In some of the cases, some difficulties are there, which were brought to the notice of the speakers, and I got the explanations about my difficulties and queries. The training on this subject is helpful to the judges who are conducting the cases and who are supposed to conduct those cases who have not conducted earlier. The cases of adoption has a link of social benefits to the parents as well as to the children. The best interest of the child is the paramount consideration about the adoption cases. Therefore, I am of view that due to the directions of Honorable High Court, the efforts taken by MGA, specifically Mr. Yerlagadda and other, the training have been conducted. The training is useful for us as the judges. I am thankful for the Honorable High Court, MGA, Yerlagadda Sahib, and all the speakers. Thank you.
Thank you, sir.
Thank you, honorable sir, for giving such a very encouraging remarks. And now, before again requesting my guest speaker, Sri Jagannath Pati sir. I would like to request any other PDJs if they want to express any views. Sir Patkar sir, are you there?
Yes.
Kindly, sir, you can express anything, sir.
I am audible, na?
Yes, sir.
I am audible.
Yes, sir. Yes, sir. Yes, sir.
In this webinar, all the queries, problems are covered. So also focus on the procedure aspect. And by this webinar, all the problems are cleared, and it will be very beneficial to the district judges who deal the adoption matter and to dispose of speedy and for welfare of the child. Thank you very much.
Thank you, sir.
Thank you very much, sir. May I request Nandeshwar ma'am? Ma'am, are you there?
Yes, sir. Good afternoon, sir.
Good afternoon, ma'am.
Sir, the seminar of both the days is very useful. All the practical queries are solved therein. Earlier, I have dealt matter when the before coming into force of this JJ Act and the regulations of 2017. So now all the procedure given in the Act is been cleared, and it will definitely help me as well as other district judges who are dealing with the cases of adoption. And I assured you that the pendency of Silvassa will clear in next month. There are only 7 matters pending, filed in the month of August and September.
Thank you. Thank you very much, ma'am. May I request Kavita Agarwal ma'am also to say a few words if she would like to. Ma'am, are you there? Kavita Agarwal ma'am. Okay. May I request Irshad Aga sir from Goa, Honorable PDJ sir. Irshad Aga sir, could you hear me?
So, may am I audible, sir?
Yes, ma'am. Please, Agarwal ma'am, please.
Sir, I have due to some administrative reason I could not join yesterday, but I have joined today. So I'm very thankful that this webinar is arranged, because I was dealing with matters and I just thought that if there had been some program on this new act, because earlier I have dealt with many cases, but not after this new act. So it was very useful, sir. And I hope we would be able to dispose of the matters as early as possible. Because in a matter pending before me is inter-country adoption, and the registration has expired, sir. So we are waiting for the certificate. Okay, sir. Thank you.
Thank you very much, ma'am. Yes, Irshad Aga sir, could you hear me? Tora साहेब आहेत का?
नाही आहे सर, नाही दिसत नाही सर.
आलेत ना, समोर दिसतात.
नाही, दुसऱ्या सर, एक मिनिट.
गोवा.
See him. Aga sir, please unmute yourself.
तिथे कुठे दिसत?
Aga sir.
Aga sir is there. He is speaking also, but I think his mic is off.
Yes,
Aga sir, unmute your mic.
Yes, Aga sir is there. I'm sorry that sir could not be heard. Sir, again, lastly, I come back to the Jagannath Pati sir to offer few comments how the program went as per his expectations, or can we make any other amendments?
Hey, sir, I think it is a very fine format with the present COVID. I also went to Maharashtra Judicial Academy maybe 4 or 5 years back, but that was not, COVID was not there. So it is a different kind of interaction, and it is nice. And participation, it was very good, I enjoyed, and we look forward also similar kind of collaboration in future. and we'll be extending to other academies and some ATIs. So I really appreciate, sir.
On behalf of the Maharashtra Judicial Academy and all my brother and sister judges who participated this online training, I express my gratitude to the firstly to the CARA, entire CARA and their team, and now to Dr. Jagannath Pati sir for today's such a wonderful session. As I expected, all the queries were raised by the participants also, and the queries have been deliberated here. I once again express my thanks to Jagannath Pati sir and his team and the members who are there to assist him, to them also. And I express my deep gratitude to the honorable principal district judges who are attending this online training for their active participation. And I express my deep gratitude to all the principal district judges also for their initiative and to depute the honorable district judges who are dealing with the cases. And my special thanks to all the participants, especially the members and the chairpersons of the CWCs and my brother and sister judges from Maharashtra, Goa, Daman and Diu. Because of your active participation only, we could achieve this. And I express my deep felt gratitude to my entire team. And finally, I express my thanks on behalf of all of us to the Honorable High Court and our Honorable Director and Chairperson of the Academy for allowing us this kind of very wonderful session. So with this, with your leave,
Sir,
yes, thank you so much, sir. Thank you so much.
Something in
yes,
the
Aga sir. Aga sir, please, sir.
No, sir. He has given thanks in the chat.
Yes. Yes, I'm reading his message. I
Yes.
would like to say that we have to try to dispose of the cases of adoption as early as possible. Yes, sir. Thank you for your message, sir. And with this, with the leave of all the participants, I would like to conclude this program. Thank you very much once
Thank you.
again. Happy Diwali to all of you. Have a
Thank you,
safe
sir. Thank you so
Diwali,
much.
and we will meet again.
Same to you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir. Mahajan sir,
Thank
Patil
you,
sir,
sir.
Ma-